Welcome to the first edition of our new LexisPSL Banking and Finance 10-minute updates. I'm Kate Gaskell and I'm joined today by my colleague Jacqueline Cook.
Hello.
Each month we'll be bringing you a selection of stories from our monthly highlights feature. For those of you who haven't heard of our monthly highlights, they're a roundup for finance lawyers of news and legal developments that have taken place over the previous 4 weeks. This month, for example, amongst other things, we included recent amendments to the LMA facility documentation and updates from the Land Registry, ISDA, ESMA and the Equator Principals Association. We also, as usual, picked out a number of journal articles from around the LexisNexis portfolio, which you may like to read in a quiet moment. Today we're going to take you through some of the updates from the May highlights. The May highlights featured a bumper crop of cases this month, including the Landesbank case on construction of a payment waterfall, the US Bank Trustees and Titan Europe case, which related to a securitization transaction, a couple of cases from April, the Re Black Ant Company case on the meaning of further advances, and the Primary Group and RBS case, which related to breach of a bank's duty of confidentiality to its customer. And we also covered a couple of cases picked up by some of our colleagues around the LexisPSL team. The Restructuring and Insolvency Guys produced some analysis on the Court of Appeal's decision in April in Casa Estates. And for any real estate finance or project finance lawyers amongst you, our construction colleagues spoke to a panel of experts about how the decision in Parkwood and Lang O'Rourke has impacted on negotiating collateral warranties. So Jacqueline and I are going to take you through 3 of these, and we're going to kick off with the Landesbank case.
In the syndicated loan market, it's common for one bank to enter into the loan documentation at the outset in various capacities, and then for the deal to be syndicated at a later date when other banks take on different roles. In the Landesbank case, Bayerische Landesbank London branch, we'll call them BLB, acted as the facility agent and as the hedging lender. A dispute arose when payments were to be made under the payment waterfall in the facility agreement. And it ran that the first payments out were to be paid to, and I quote, unpaid fees and reimbursements of unpaid expenses or costs, including break costs and hedging break costs of the facility agent. So the question arose, would this also cover the costs of BLB in its capacity as a hedging lender? The court said no, it would not. It would only cover the costs of BLB in its capacity as facility agent. So there's nothing new in this particular case, but it is a reminder that if a party is acting in more than one capacity, we have to be clear in the drafting of the payment waterfall. And where there's a hedging arrangement, we have to make sure that you consider all the payment flows from the hedging. The LMA intercreditor agreement for acquisition finance is a good starting point if this is new to you, because it does look at all the different payment flows coming out of the hedging agreement.
Thanks, Jacqueline.
Okay.
So I'm going to take you through the Re Black Ant case. This was a case about the meaning of further advances under statutory rules on tacking further advances. Tacking further advances essentially means adding on additional advances to any initial advances. And the concept is relevant where you've got 2 creditors or more who have competing security over the same assets. So let's imagine that we've got a creditor, A, who has lent £100 of a £200 facility to a debtor. We then have a second creditor, B, who comes along and also lends £100 to the debtor, secured by the same assets as A's security. Under the normal rules on priority, if A then advances the second £100 of its facility to the debtor, knowing about B's loan and B's security, then the security for A's second £100 will rank behind the security for B's loan. Now, situations like this are normally dealt with the parties entering into a priority deed, but there are certain statutory rules relating to security over land contained in the Land Registration Act, which allow the first lender to tack further advances to its initial advance without losing its priority position to a second competing lender. So this case, the Black Ant case, was about the meaning of the term further advances. Essentially, the key fact in this case was that the first lender had asked the debtor to amend the terms of the original facility letter, amongst other things to include some new standard terms of conditions of business. The second lender argued that the effect of this new facility letter was to deem the original advances repaid and further advances made so that the first lender lost its priority position. The court disagreed with this argument, not least because the facility letter made no mention at all of any sort of deemed repayment and further advance, which in any case, the court said, would serve no useful commercial purpose. The court told us that the ordinary meaning of the term further advances is an advance of further or additional funds. The decision isn't all that surprising given the facts in this case, but it is interesting because, as the court observed itself, there's very little direct authority on the meaning of further advance.
So now we're in the area of structured finance. In a securitisation transaction, the servicer is the person who gathers in the payments from the underlying assets and pays them into the financial structure. Here, in the case of US bank trustees and Titan Europe, an Irish SPV was set up to issue floating rate notes which are due in 2017, backed by a portfolio of UK healthcare properties. The deal was set up as a commercial mortgage-backed securities transaction, which is known as CMBS. So the servicer would collect payments under the mortgages and use these to pay those into the structure to serve as the coupons and the principal under the notes. Here we had notes from Class A to Class E, which ranked in different priorities. The property portfolio dropped in value to about a third of its original value from 2007 to 2013. This triggered the right for a special servicer to be appointed. It was clear to the special servicer that there would not be enough cash in the transaction for all of the notes to be paid out, and that possibly only the Class A notes would be paid. So it decided to sell the portfolio and exit the deal. Another party in the transaction, who happened also to be a Class E note holder, claimed that it had the right to appoint a successor special servicer in place of the special servicer. It thought the special servicer was selling the property portfolio prematurely and that wouldn't get the value realised in the sale to be able to pay off all of the notes. However, the issuer, which was the Irish SPV company, claimed that it was the person who had the right to appoint a successor servicer. The court saw that there were inconsistencies in the offering circular to the underlying documents, and it held that it would interpret the underlying documents by references to the normal rules of interpretation and not by reference to the offering circular. It concluded that it was the issuer, in fact, who had the right to appoint the special servicer, and the issuer would consider the rights of all of the note holders, not just of one particular class. So what can we learn from this case? Well, the offering circular should always be an accurate reflection and summary of the transaction documents. The offering circular is also not usually used by courts to interpret and aid interpretation of the underlying documents. The servicer is important to collect the monies from the underlying assets and pay them into the financial structure, in this case, the commercial mortgage-backed security structure. It's vital that there is clear and precise drafting in relation to the appointment and the removal of the servicer so that we can avoid disputes of this nature.
Thanks, Jacqueline. So thank you very much for joining us for this update. If you want more information like this, then the LexisPSL Banking and Finance team produces a weekly roundup as well as the monthly highlights and our usual daily updates. There's more information on our website. We hope you'll join us for our next 10-minute update, which will come out in the week of the 7th of July, covering some highlights from June.